Good afternoon, everybody. I hope everyone's well. Welcome to sunny Manchester. Also, I should say Happy International Women's Day to everybody. Hope you're having a great day so far. Welcome to the Squire Patton Boggs Hot UK Employment Law session for 2024. I'm joined today by my colleague Jane Saunders. My name is Bryn Doyle. For those of you who don't know me, I'm a partner based here in the Manchester office. We've got a lot to get through, so we'll kick on. Oh, there's Jane and I, by the way. Just a few housekeeping, as we always have to do with these things. So we're using WebEx today. If you want to ask a question to us, please do that. You'll see the bottom right hand corner there is a Q&A function, so please click on that Q&A function, ask a question. What we'll do is we'll go through the session, and then time permitting at the end we will answer any questions that have been put through. So but if we don't get a chance to answer all those questions, then what we'll do is we'll reach out to those people who've asked those questions and give you an answer as best we possibly can. The other point just to say is that we will circulate the slides at the end of the session and also the recording. So if you miss some elements of it or whatever, then you'll get a copy of the slides and the recording after the session. So what are we going to have a quick look at today? Well, there's an awful lot going on, isn't there, in relation to both legislation and case authority. But we're particularly going to pick up on these things that you can see on the screen now. We're going to look at things like the flexible working rights. We're going to look at in a bit of detail on the mandatory duty on employers to prevent sexual harassment as well. But there's a lot going on, so without further ado, I will let Jane crack on.
Thank you, Bryn. Good afternoon, everybody. We're going to start today with flexible working arrangements. This will be something that you're familiar with already. The right to request flexible working has been in place for a number of years for certain employees, and the current position at the moment is that all employees with 26 weeks continuous service can make a request to change their working hours, maybe their work pattern, maybe working from home, those kind of tweaks. There's only one opportunity at the moment each year that they can make this request. So we have got these changes here that you can see summarised on the slides, and these come into force from the 6th of April. The first one is that all employees will have the opportunity to request flexible working from day one, so they don't need the 26 weeks or 6 months service before they can make that request. There'll also be the opportunity to make 2 requests in any 12-month period rather than the current once a year right. Employers will be under an obligation to consult an employee before rejecting a request, and the decision period within which the employer is required to process the request will come down. It's currently 3 months and it's going to be 2 months. Employees are no longer required to explain the effects that the changes they're applying for would have on the employer and how they might be dealt with. So that's quite a bit of a change. At the moment, we do have the opportunity as employers to say to an individual asking changes, well, how do you think this is going to impact on your job, how you do your job, how your colleagues manage their work? That's going to actually be taken away, which is quite a change. There's an updated ACAS statutory codes practice on handling flexible working requests. That's expected to come into force this year in April as well. Having said that, if you don't comply with the code, that in itself isn't going to expose you to any risk of a claim, but it can be taken into account by the tribunal in any proceedings. So when the code of practice is in force, it is worth having a look at that if you're dealing with any flexible working requests, just to refresh your memory on what ACAS thinks is a good idea in terms of the approach. Action points: check your policies and procedures, make sure that the managers you're dealing with are aware of the new rights and obligations. But broadly, I would say, other than the technicality around the time periods and the number of requests, we're still going to be dealing with requests in the same way. We're still going to be looking across the workforce and making sure that these are going to be requests that we can accommodate. It isn't going to be the case that employees are entitled to ask for whatever they want and just have that rubber stamped. So it's just about thinking through the process, making sure you comply with all the procedural hoops that you need to, and you're aware of the changes to the time frame. And I don't know what you're all experiencing at the moment, but from talking to clients, it does seem that there is an increase in flexible working requests coming through at the moment, and that's before these changes have even come into force. probably because many of our clients and other employers are asking those working in a hybrid basis to spend more time in the office than they have done since the pandemic. And so as a result of people being used to working at home more, they're now looking at changes they can make to their working arrangements via a flexible working request rather than under the hybrid working policy, because the policy is getting a bit tighter for them and their employer is expecting them in the office more than they really want to be. So that trend may continue as we see a greater return to the office for more people. The next thing we're going to have a look at today is pregnancy protection. So you probably know already that employees who are on maternity leave, who are selected for redundancy, have a special protection, which means they have priority over any vacancies that may exist in the organisation, which would avoid their dismissal by reason of redundancy. So once an employee on maternity leave has been selected for redundancy, her current job is gone, she then has priority over other vacancies that she's able to do. Even if there's a better candidate for the job, she automatically gets it because she's on maternity leave and she has that special priority protection in place. And that protection actually extends to employees on adoption and shared parental leave as well, but we tend to talk about it in terms of employees on maternity leave. So this change here, which is coming in from the 6th of April, this is quite a significant extension to that protection, and it probably will be very important to let any managers who are dealing with proposed redundancy situations know about this because of the change. And what the change does, it means that that protection during maternity leave is extended. It extends through pregnancy and it extends longer after the individual has returned to work. So from the first moment that you are informed that somebody is pregnant, right the way through to 18 months after their child is born, they will have this priority protection. As I say, it applies once they've been selected for redundancy, so their existing role is no longer there for them, and they're looking for an alternative vacancy to avoid their dismissal. It doesn't mean that you can't make people on maternity leave or who are pregnant or who are in that 18-month period after childbirth. It doesn't mean you can't make them redundant. It doesn't mean you have to make a job for them. It doesn't mean you have to make somebody else redundant to keep them. But what it does mean is if there's a vacancy that they're capable of doing and they have been provisionally selected for redundancy, you must offer them that job, not put them through a competitive selection, not look whether there's anybody better for the job, but actually offer it to them outright. The next thing we're going to talk about today is carers leave. And carers leave is something entirely new. This is a statutory right that's going to be in place, allowing employees to take 1 week's unpaid leave each year. And the leave is going to be available for employees who need to take it to care for a dependent with a long-term care need. And part of the reason for bringing this change in legislation in is because there is, according to a recent survey from 2020 and 2021, there's approximately 4.2 million people across the UK who are providing unpaid care. And that could be looking after an elderly relative, a disabled family member, or any other dependent. And the statistics are that the majority of those unpaid carers are women, and they are women who are aged over 50 years old. So if you think about that age category, you know, a lot of people are still in work. It isn't people who have retired or who otherwise don't work. So it's people who are trying to balance their work alongside their caring responsibilities. And at the moment, there isn't any statutory leave entitlement for this kind of informal carer. So that maybe they're taking holiday, maybe they're having to take other kind of unpaid leave, or in fact leave paid employment if they need to juggle that against their caring responsibilities. So this carers leave, which will come into force on the 6th of April, kind of plugs that gap. What it means is that an employee who needs to be absent from work to either provide care or arrange care for their dependent with a long-term care need can make a request. They could do it from day one of their employment. There isn't any qualifying period. and they are entitled to take up to a week in any 12-month period. And that can be broken down into half days, individual days, couple of days, or a full week. And there are notice requirements. So for any half day or 1 day period of leave, they'll have to give 3 days notice. And for any longer periods of more than a day, the individual will need to give twice as much notice as the requested leave. So if they want 2 days off, they need to give 4 days notice, 3 days off, 6 days notice, and so on. Interestingly, employees are not required to provide any evidence in relation to their request for carers leave. So if you've got any kind of cynical thoughts about people abusing this right, I suppose people who are not perhaps going to tell the truth about the circumstances of which they need time off, and you might sometimes want to test that with them, you're not going to be able to ask for evidence. Having said that, with the notice requirement, with the fact it's unpaid leave, hopefully it isn't the sort of thing that people will abuse, maybe when they want to pull a sickie or they've sort of had a long weekend and they don't want to come back. It will be something that's planned in and it will be unpaid. If you are asked to grant some carers leave, you can't refuse entirely, but you can delay it. So if you're unable to accommodate the request for leave when it comes in, you need to agree another date within 1 month. You need to write to the employee who has asked for the leave to explain why you can't accommodate it and to agree the new date in writing. The sort of action points will be recommending a policy to reflect the new statutory rights. It's probably a standalone policy unless you can add it on if you've got kind of a general other leave policy that you could add it on to. And the types of things that I think will be helpful for managers and employees to know in that policy are, well, what does dependent mean? What kind of people can I ask for this time off for? It is quite a broad definition, so it could be the employee's spouse, their civil partner, their child, their parent, also somebody who lives with them, but not somebody who is a boarder or a tenant. It has to be somebody who's living with them, but not on that kind of more commercial footing. But it also is as broad as somebody who reasonably relies on the employee to provide their care or to arrange their care for them. So it is quite broad. As is the definition of long-term care. So that's something else you might want to include in the policy. What does it mean, somebody who needs long-term care, has a long-term care need? It extends to someone who has an illness or injury which requires care for more than 3 months. And that illness or injury could be physical or mental. So somebody who needs 3 months care or more, or if they're disabled as defined in the Equality Act. And also if they require care for a reason connected with old age. So quite a broad spectrum there. It is going to be quite far-reaching. So hopefully helpful to people who need to avail themselves of this and don't want to use all their holiday each year in supporting people they care for. There are also going to be employment protections. None of these will be a surprise, but taking carers leave will give the employee the same kind of protections as other family leave. So protection from dismissal or detriment if they take the leave or if they apply for the leave as well. So the final regulations have been published this week, and as I say, it's going to be enforced from the 6th of April, that right. With the kind of leave entitlements, we're looking now at paternity leave. So 8th of March today is one of the key dates in relation to the changes for paternity leave. And what is going to happen is, it's quite minor, but I think it will be helpful for people who want to take paternity leave. So at the moment, fathers and partners are entitled to take up to 2 weeks of paternity leave. They can either take them in 2 separate blocks of 1 week or at the same time. And they must take them within the first 8 weeks after birth. That's going to change so that the paternity leave can be taken at any time in the first year. They're giving a bit more flexibility if somebody wants to tag it on towards the end of their partner's statutory leave, or wants to take over when their partner goes back to work to aid some of that transition, settling in time at the end if they prefer. So a change in when during that first year the leave can be taken. The second change is going to be to notice requirements. And the reason for the change is that it is difficult to know exactly when you want to take that paternity leave. And so the government's trying to offer a bit more flexibility for working parents in planning their leave and taking the time off that they need. So at the moment, fathers, partners are required to notify their employer of leave dates 15 weeks before the expected week of childbirth. So we know anything can change in that 15-week period when waiting on a baby. And so the proposal now is that fathers-to-be and partners will be required to give notice of entitlement at that 15-week stage before childbirth. So letting their employer know, I'm expecting to take some paternity leave, I am eligible, and hitting that 15-week mark in terms of notifying of the circumstances. But then they only need to give 28 days notice of the day they actually intend to take their leave. So that just gives a little bit more flexibility to the person who's going to take that paternity leave. And the changes actually are in force as of today, which is why we've put that key date of today on the slide. And they apply to children where their expected week of childbirth begins after the 6th of April. So the April date, as we see a lot of legislative changes, or children who are expected to be placed for adoption on or after this date. So the 6th of April date in that case as well. I suppose action points here will be, again, looking at your policies, making sure they are up to date with the change in statutory protection, and also that staff are aware of these. If you want to go beyond what the basic statutory minimums are in this area, obviously you can, and many employers do, but that's not mandatory. These are the limits of the paternity leave process. And obviously, Bryn and I would be happy to help you if you want to talk any further about policies and guidance or your normal contact at Squires. If you're looking at your to-do list partway through this call and thinking, I've got a lot of policies I need to have a think about, just get in touch with any of us if you'd like any support in doing that. So moving on from family leave now to changes to the working time regulations. For probably 10 years, maybe slightly more, we've been having lots of case law and interesting discussions about holiday pay and working time regulations. And Brexit came into the mix and gave us all opportunities to scratch our heads and wonder what was going to happen. The government has now confirmed in respect of holiday under the working time regulation that it's not going to introduce a single annual leave entitlement with a single rate of holiday pay. So what does that mean? Because of the working time regulations coming from the Working Time Directive, we have a two-tier holiday system. So the first 4 weeks of mandatory statutory annual leave is treated in one respect, and the second pot, which is just a further 1.6 weeks, is kind of a top-up and treated in another respect. And the reason for that is the first 4 weeks came as an entitlement from the Working Time Directive, so European legislation, and the 1.6 weeks top-up was a UK-only thing, which meant that separate rights and obligations applied to those two separate little pots. We'd hoped or thought that what the government was going to do was make those into a single annual leave entitlement with the same rights applying across all of the 5.6 weeks, but it's decided not to do that. The reason this has been causing difficulties, as many of you will know, is the calculation of the 4 weeks. So the first pot is the sort of European Directive holiday. The calculation of the pay for that period has had a lot of interesting case law looking at whether overtime needs to be included, whether commission needs to be included, whether any other irregular payments or regular payments beyond the basic hourly pay or salary need to be included. And it didn't extend over the 1.6 weeks top up, which makes it a very complicated system. What the government has said is, okay, we're not going to help you by rolling these two pots together and making it more straightforward and just having one single rate of pay across the lot. But what we will do is we'll give you some guidance in the working time regulations about what you should include when you are calculating the normal rate of pay. I'm not sure that what the government is doing here is actually going to change anything for you, because the types of things that they're going to include are things like commission payments, which are intrinsically linked to the performance of tasks that the individual's contractually required to do, payments for length of service, seniority, and other payments like overtime that have been regularly paid. So effectively, they're taking the case law, they're codifying it into the working time regulations. As I say, I'm not sure how much difference that'll make to you in practice, but there is going to be some guidance to support employers in relation to the change, but we don't see that yet. So let's wait and see if that's going to give us any more clarity, but I don't think so. But just worth remembering, therefore, that there are these two pots of leave to think about when you're looking at your holiday pay. Another element of the change to the working time regulations is in respect of irregular hours and part-year workers. This won't apply to every employer. It will only apply where you have those groups of individuals in business. Irregular hours workers, what does that mean? So it basically means that the number of paid hours that an individual works each pay period, whether that be weekly, 4-weekly, monthly, is variable. So they do different hours each week, or it changes from time to time. A part-year worker is somebody who perhaps is a term time worker, perhaps they have all of the school holidays off, and so they're only required to work part of the year, and there are periods within the year where they're still under contract, they're still employed, they're just not required to come in and do any work. So we're looking at casuals, irregular hour workers and part-year workers here. And what the working time regulations say is, actually, we're going to let you do rolled up holiday pay for these people, which is quite helpful, I think, from an administrative perspective, if you choose to go down this approach. Because what it says is, each hour that the person works, who's a casual person, so an irregular person or a part-year worker, each hour they work, they will be entitled to 12.07% as holiday pay. So you're not so much worried anymore about granting the leave, paying them for the leave, how many days paid, how many days unpaid. We'll have a formula that says, if you pay them rolled up holiday pay at 12.07% for the hours that they work, you will have satisfied their entitlement to holiday pay. And you will need to itemise on your pay statements, so on your pay slips, how that 12.07% uplift to remuneration has been calculated, so that it's transparent and everybody can see that it's been paid out, which may be you need to have a look at your payroll systems to see whether it's possible for you to do that if you do have casual workers or part-year workers. And obviously making sure that those casual and part-year workers understand, is this going to happen to me? Am I going to get rolled up holiday pay, or am I still going to take paid periods of holiday at certain times during the year? So there'll be a kind of a process internally, operationally rolling this out, making sure payroll are aware, making sure managers are aware, making sure employees who are impacted are aware. I think overall this is a positive step for us, because it means that we are able to have a bit more certainty around what these categories of employees are entitled to as part of their holiday pay entitlement. And after this, we're going to look at fire and rehire. So fire and rehire, you might remember, got a lot of press just after the pandemic around an opportunity to change workers' terms and conditions who won't agree to the change by dismissing them and offering their job back, basically, on different terms and conditions. And they got a lot of negative press because employers, even though they were acting within the law, employers were seen, particularly by certain trade unions, to be acting in an unfair way. So the government, what they've done about this, they've issued an updated draft of their statutory code of practice. And the statutory code of practice deals with the dismissal and re-engagement circumstances where you're trying to terminate employment under an old contract and re-engage people on new terms and conditions. So it's an opportunity to put more favourable terms in, to take away legacy terms that are unhelpful for your business. But the government is telling us that there's going to be a certain way that we should behave as an employer when we're trying to do that. And although the statutory code is, I think, about 16 pages long, it can be distilled down to probably quite a much smaller list of important items. And you do see quite a lot of repetition in that statutory code in terms of what the government is asking of us. And obviously the purpose of it is so that the individuals who are going to be impacted by this have plenty of advance notice. They can engage in meaningful consultation in good faith and try and reach them out at a good outcome. All the kind of things that you're probably doing already if you've needed to rely on this and be clear and upfront. You're not allowed to use the threat of dismissal as kind of a way to force people to agree to changes to terms and conditions to avoid that. So you shouldn't unreasonably threaten that earlier or use it as a negotiation tactic to put kind of undue pressure on people. It's all, as I say, quite high level under the actual code of practice. But this is a code of practice that we need to take account of and be aware of, because the important aspect of it is that the tribunal will be able to look at how we've behaved in compliance with that code when deciding unfair dismissal claims, and particularly when deciding compensation amounts under unfair dismissal claims. And similar to when the ACAS code came in and there was an opportunity to uplift for a failure to comply with that, this particular code on fire and rehire, the tribunal will have the power to increase compensation by up to 25% if an employer unreasonably fails to comply with the code. And on the flip side, they can decrease an award of compensation by 25% if the employee has unreasonably failed to comply. So it is similar to ACAS code in that respect, and it's something we need to have read, absorbed, make sure we can find the spirit of if you're looking to change terms and conditions and thinking that dismissal and outcome might, dismissal and re-engagement might be one of the outcomes you're looking at, even though in practical terms, I don't think this is necessarily going to change the burden on you in terms of how you're currently operating. We don't actually have a date for implementation for this code yet. Likely to be this summer, but watch this space for further information. And I suppose just have this in the back of your mind if you know that the business is thinking about projects for changing terms and conditions, so that you're aware to have a look at it as and when those kind of projects get going. A couple more things from me today. The first one really only apply to you if you're a business in hospitality, leisure, service sector. This is about tips and gratuities. Most businesses are operating in line with this new legislation already. We're expecting this legislation to come into force in July, and we're expecting a code of practice. We don't have an implementation date or a code of practice yet. What's going to happen is that there's going to be a statutory obligation on employers, so that tips, any other service charges, gratuities, etc., are passed along to the employees actually doing the work. So making sure that it is the whole amount is given. They can't take a percentage off the top as the employer or the business, and that they share it out fairly to the individuals who are working at that place of work. And employees will also have rights under this new legislation to ask questions and for information about how are my tips paid, and there'll be the right to bring a claim if the tips aren't shared out fairly and properly in accordance with the Act as well. So as I say, I've noticed myself, even, if you just, even if you're not working in these sectors, if you've gone out for a meal and sort of talking to staff about, are you going to get this tip if I put it through on the card machine instead of leaving the money on the table? Generally, the employers have already implemented this, even without the legislation coming in. So just keep that one in mind if you are operating in those sectors. And last one from me today is about the TUPE regulations. So you'll know that in respect of TUPE transfers, where we have employees who are subject to a transfer and we're the outgoing employer, we need to be thinking about information and consultation with those transferring employees and other affected employees. Normally that's with any trade union reps, if we've got a recognised trade union. It might be with pre-existing employee reps, if we have an employee forum or representative group who were elected with a mandate for covering TUPE consultation as well as whatever else they look at. And if we don't have TU reps or pre-existing employee reps, we need to elect reps for the purpose of information consultation for TUPE. And these minor changes to the TUPE regulations are going to change the position where there are no pre-existing representatives. So what's going to be the case is where there are small businesses, so if you're a business with fewer than 50 employees and you're going to be having a TUPE transfer, or if you're any size business and there's going to be a transfer with fewer than 10 employees, you're now going to have the opportunity to consult directly with the employees who are affected, rather than having to go through the administrative hassle of electing a representative for whichever groups as part of the information and consultation process. So it seems like a minor change, and it's probably the way a lot of businesses are operating at the moment, but it is helpful because, as we know, a failure to inform and consult can come with a maximum penalty of 13 weeks' pay for each affected employee. So the government recognising that they're actually giving people the information that they need in respect to the TUPE transfer is more important than it going through an employee representative, where it's manageable to give it to the individuals directly. Having that codified in the legislation is really helpful. And the changes will apply to transfers that take place on or after 1st of July. So if you're a small business, you've got 50 employees or fewer, or if you're a large business but you're dealing with a small transfer with fewer than 10 employees, then do remember to check back to exactly what the TUPE regulations say differently about those smaller TUPE transfers when you're thinking about information and consultation. If you don't recognise a union for those individuals and you don't have a pre-existing employee body who can deal with that for you.
Great, thanks so much, Jane. That's fantastic. Thanks for taking us through all of those. I'll take up the baton now and have a look at some other changes that are due to come in over the course of the next year or so. The first one of those is the snappily titled the Workers' Predictable Terms and Conditions Act of 2023. As you can see from the slide there, we don't yet have a date as to when exactly it's going to come in, but it's probably going to be later this year in the autumn. What this is going to do is it's going to give workers who have unpredictable working patterns the right to make a formal application to change their working pattern to make them a bit more predictable. It's off the back of the government's commitment to introduce legislation to give workers the right to request a more predictable and stable contract or stable working conditions, which is all great. Time will tell as to how it's actually going to apply in practice. ACAS have published a draft code of practice on handling of requests under the legislation, together with a consultation which is seeking to obtain views from people in respect to the draft code. Unfortunately, given neither the Act or the code make any attempt to define what predictable actually is, there's going to be quite a lot of overlap here in terms of what what the existing flexible working regime will be, and I think that's going to lead to quite a lot of headache for employers. So it's kind of watch this space really in terms of what that looks like. There are some action points for employers. Keep abreast of what's going on. If you're going to introduce a policy for the handling of these types of requests, then we would advise that you come and speak to your friendly SPB lawyer, because I think an interpretation of what the code says is going to be quite important, in particular what the definition of predictable actually is. Like I said, those new rights are likely to come into force in about the autumn, according to a fairly recent government press release. So just keep an eye out for that. I should also say that we have some blogs on this as well. So have a look at our blogs, which go through this in a fair bit of detail, which is really interesting and helpful as well. Next is perhaps the area of the law that's going to change, which certainly in my practice has been the area that's been keeping me the most busy, and that's this new mandatory duty on employers to take reasonable steps to prevent sexual harassment. So we don't know exactly when this is coming in. It's probably going to be autumn. The last I heard, they were thinking probably September, October time. We don't have a defined date, but keep a lookout for that. Effectively, what it's going to do is it's going to increase the duty that's already on employers in respect of sexual harassment and reducing sexual harassment in the workplace. Of course, the Equality Act is going to be amended, and this new mandatory duty is going to require employers to take reasonable steps. Now, the issue then is going to be, well, what are reasonable steps going to look like? It will depend upon specific circumstances. So the size of the employer, the sector of that the employer operates within are going to feed into what is and isn't reasonable. But ultimately, the final decision maker in terms of whether something, whether an employer has or hasn't taken reasonable steps, is going to be the employment tribunal. The government has promised us a new statutory code on, or code of practice on, and some further guidance on this, and they have said that they're going to include some examples of the things that employers can take could take in terms of reasonable steps. We've also seen reports the Equality and Human Rights Commission have said that they intend to update their existing guidance in respect to sexual harassment and harassment at work to reflect this new the new duty. Like I said, time will tell as to what that actually looks like, but I think it's fair to say that the bar at the moment is relatively low in terms of what employers are required to do to prevent sexual harassment in the workplace. I think that bar is probably going to go even lower. Speaking to clients, training that I've been doing with clients over the course of the last 6 months or so, we do think that just saying I've done some training to prevent sexual harassment is unlikely to be enough. It's got to be a cultural shift. It's got to be a change that demonstrates that an employer is living those values to genuinely try to avoid this sort of thing from happening in the workplace. Some of the changes that we do know, or we think we're going to happen, will be that any breach is likely to be enforceable in 2 different ways. Firstly, the Equality and Human Rights Commission might take enforcement action against an employer. That's going to be a kind of naming and shaming type scenario. You as an employer have failed to prevent sexual harassment from taking place in your workplace, so therefore we now require you to do X, Y, and Z. There's also going to be, similar to what Jane was talking about, the potential for an uplift of 25% of any tribunal awards. I would imagine that's the more likely angle that of enforcement the tribunal is going to do, i.e. if an employment tribunal finds that an act of sexual harassment has taken place and it's obvious that the employer could or should have done more to prevent that from happening, then we're going to see an increase of up to 25% on top of any awards made in respect of that claim that's been brought. Feels to me like it will, it's hard to tell, but it will be starting at 25% and then working down for anything that you might have done to try to prevent it from happening. But it's going to be very interesting over the course of the next couple of years to see how the tribunal interprets this, because of course there is already legislation in force that is intended to stop sexual harassment from happening in the workplace, but it's this reasonable steps element of it which is going to become into sharp focus for us. So what should employers be doing? If you haven't already done so, we need to make sure you're developing and communicate effective anti-harassment policies, specifically sexual harassment policies as well. I do have a few clients who've decided to have a standalone separate sexual harassment policy that doesn't necessarily fit within their anti-harassment policies. Now, I'm not saying that that's necessary in every case, but it may well be worth just giving some consideration to whether that works for your business, particularly if you're in a business that this might be particularly applicable to. Review the steps that you're currently taking to prevent sexual harassment in the workplace, and give some thought to what additional steps you might be able to take to prevent it from happening. Like I said, I don't think just simply saying, well, we sent everybody in on a training course is going to be sufficient for some businesses. I think you've got to be able to demonstrate, what else have you been doing to try to prevent sexual harassment from taking place in the workplace? So have you got certain groups set up? Are you looking at various different ways in which to educate and to prevent these sorts of things from happening? So it is worth just keeping an eye on that. And as a shameless plug, we are, as a firm, rolling out some excellent DEA training solutions training. So please do get in touch with either myself, Jane, or one of your usual SPB contacts if we can help you. Look on social media, there's quite a few links here to what the training program looks like, but it's got some really useful stuff on there which will cover in a lot more detail, in particular the prevention of sexual harassment that employers are going to be required to do. Okay, so moving on to the future, and if a Labour government gets into government in the next year, what would that look like? Now, the first thing, of course, to say is that there's absolutely no guarantee that that will happen, irrespective of your political persuasion. It is worth thinking about whether or not a Labour government do come in, because as employment practitioners, whether you're an HR or you're an employment lawyer, it's certainly something to take into consideration. So the starting point is the October 2022 New Deal for Working People paper, which the Labour Party published, and that set out a number of proposals, which they called a comprehensive package of reforms, and tied themselves into those being implemented within 100 days of a new Labour government being formed. Again, time will tell as to whether or not they stick with that time frame, but I think it's right to assume that they will at least try to implement some of these things if they get into power. The paper was republished in January of this year, and in February, Angela Rayner confirmed that a new Labour government would introduce draft legislation within that first 100 days. So it is, as I say, worth taking into consideration. So what does it look like? There is an intention to introduce a genuine living wage for all adult workers. So that's worth taking into consideration. The banning of 0 hours contracts, the ending of the fire and rehire culture, scrapping qualifying periods for basic rights, which may include the right to bring unfair dismissal claims, sick pay, parental leave, those sorts of things. So for many employers who currently have the approach where they go, well, do you know what, this person doesn't have 2 years service, so therefore we're not necessarily going to follow proper process, that could be quite important. They intend to make any family-friendly rights stronger, although I haven't really defined exactly what stronger means. I think one thing that is fairly clear will happen, certainly in my view, is that they will look in detail at trade union law and trade union legislation. And in particular, I think that they will look to repeal some of the more recent anti-strike legislation if they get into power. So that's certainly worth thinking about. There is this issue of bringing in a right to switch off. Again, there's not a huge amount of detail on what that looks like, but it is worth, again, giving some consideration to that. So, and also to go further and faster in closing the gender pay gap, and looking at whether or not they can extend more than just gender pay gap, looking at other areas of the law as well. They've also indicated that they'd like to make changes to discrimination legislation, looking at potentially extending equal pay claims to cover both ethnicity and disability, and introducing the potential of an interesting area of law of dual discrimination. So that's where someone might be able to bring a claim if they've been discriminated against on the basis of 2 concurrent protected characteristics. So being a woman and being disabled, but being able to bring a claim in respect of both of those, not separately, but together almost. Not surprisingly, quite a lot of those proposals have drawn quite a lot of concern from some areas of business. You may have seen that Rupert Soames, the president of CBI, had, in his recent interview with the Financial Times, said that he was warning his members to wake up and smell the coffee, because this is something that's coming down the track. So if you're an employer and you are predicting a Labour win at the general election, then it is certainly something to take into consideration, worth thinking about. Obviously, we're going to have to wait and see. We're going to have to wait and see what happens. There's clearly no guarantee that a Labour government are even going to get in, and even less guarantee that they'll actually do all of, or even some of the things that they say that they're going to do, and certainly within that first 100 days. But I think it is certain that even if Labour don't get in, there will be changes to employment legislation in the future, not least for those things that we've already seen, but in the future there are some other things on the horizon too. So keep a lookout for that, and obviously stay close to your local Squire Patton Boggs representative, and no doubt they will help you understand all of that as well. Okay. Next one, just to give some considerations to, is the national living wage and national minimum wage. Hopefully most people are aware of the increases. Just a reminder really that the national living wage currently applies to workers aged 23 and over, but following some recommendation from the Low Pay Commission, that age threshold is going to be lowered to 21 from April of this year, so keep a lookout for that. Many businesses are still being caught out by what seems to be a rather innocuous practice. For example, staff paying for any uniform in connection with their own employment, which is inadvertently dipping them below the national minimum wage rates. And we're certainly seeing quite a few clients who are being investigated for breaches of payment of national minimum wage rates as a consequence of these sorts of things. So just keep an eye out for that, particularly as kind of the cost of living goes up. Many employers are thinking, well, okay, fine, well, we've got this cushion, but actually if things cost more to buy, then of course that's going to have an impact upon the national minimum wage rate as well. We have done a blog on this, you'll be pleased to know, so it's worth having a look at the blog, and that's quite a useful one because it offers 6 pitfalls to avoid. All of those remain valid, but the long and the short of it is that the rules are pretty complicated, but it is worth just taking into consideration those changes to national minimum wage. Next slide. Yeah, increasing the rates and also increasing the tribunal awards. For those of you who unfortunately have to defend employment tribunal claims, you will no doubt be aware that the compensatory award for ordinary unfair dismissal has been increased from £105,000 to £115,000, and the maximum amount of a week's pay for the purpose of calculating statutory redundancy pay and the basic award and unfair dismissal claims is going to increase from £643 to £700. That's going to apply from 6th of April 2024. Note that SSP is going to increase to £116.75 per week, and other rates of pay that you can see on the screen there are going to increase to £184.03 per week. It's worth, just remembering that the cap on the compensatory award for unfair dismissal purposes is, of course, the lower of the statutory limit set out above, or 52 weeks for the individual concerned. Okay, just to finish off before we have a quick look at some of the questions that have come in and the EU element of it, a few other developments to be aware of. Neonatal care leave and pay. The government's passed some legislation that's going to introduce new rights to leave and pay for employees with responsibility for a child who's receiving or has received neonatal care. The draft regulations set out the full details of the new protections, haven't yet been published, but we think that the government's targeting around about April 2025. Apparently that's to give HMRC sufficient time to set up the necessary systems for neonatal care pay. Most people will no doubt be aware that there is the threat of the return of tribunal fees. If you're a subscriber to our blog, you'll have seen that's been commented on. The proposal is that it's going to be a flat fee of £55, so significantly less than the previous fees that were introduced and obviously then were repealed. That's going to cover the claim all the way through to the hearing, then with a further fee of £55 if that claim gets appealed to the Employment Appeals Tribunal, etc. So just worth thinking about that. The consultation for that is still open, so if that's of a particular interest to you, then do feel free to reply on the consultation on that. Non-compete clauses, we've talked about this in the past. On a number of occasions actually, but you'll remember that the government is proposing to limit the maximum duration of non-compete covenants in UK contracts of employment. And so it is worth just bearing that in mind if you are in the process of drafting your employment contracts, etc., to just keep an eye on what that looks like. And again, do reach out to your friendly SPB lawyer for any help and assistance with that. In terms of the timing of any new legislation, government said that it's going to bring that forward when parliamentary time allows. So who knows when that's going to be. It seems unlikely that that's now going to happen before the general election. So it may well be that some or all of this doesn't happen, but watch this space. Finally, before we do the questions, just a couple of key updates on EU developments. I appreciate that the United Kingdom is no longer part of the EU, but developments in the EU are always relevant to what happens both here in the UK and for those businesses that have operations both within the UK and also in the EU. There are two particular topics to mention that we thought would be of relevance. The first is the Pay Transparency Directive. Hopefully, you'll be aware, have seen that the aim is to tackle ongoing inadequate enforcement of equal pay rights by establishing pay transparency standards to empower workers to claim the right to equal pay. The directive includes provisions requiring employers with at least 250 workers to publish information on their gender pay gap. And part of the wider global trend is around pay transparency. It's something that we'll be picking up on part of our global webinar program as well, so do keep an eye out for that. The other area is AI regulation. It's obviously a massive topic, AI, at the moment. The Council of the European Union has published the latest version of the Artificial Intelligence Act. That's expected to be approved by European Parliament a little bit later this year, probably April. And it's likely to become the first major global regulation of AI systems. So think GDPR, that sort of situation, where it comes a specific piece of legislation that regulates AI across the European Union. If that happens, then there will inevitably be consequences that are going to impact those of us who operate here in the United Kingdom. It's not an employment-specific measure, but it is going to have implications, I think, for companies that use AI systems in relation to their workers. And of course, AI is a huge topic here in the UK as well. As you'll be aware, there's no current legislation dealing specifically with AI in the UK in respect of employment, but it is worth just giving some thought to whether or not your AI tools, for example, in relation to recruitment, could perhaps lead to acts of discrimination, thinking kind of algorithms, those sorts of things, whereby it may leave your business exposed to acts of discrimination or potentially for breaches of any regulation that comes in. So we have just 5 minutes left. So there are a couple of questions. Jane, I don't know whether there is a question that's come.
Sure, I'll take a question. So one of the matters that I was talking about earlier was the redundancy protection for employees who are on maternity leave, and how that's now going to be extended so that an employee who has told you she is pregnant or who has had a baby within the last 18 months is entitled to the same priority over alternative employment when selected for redundancy. A question came in around the difference between original selection for redundancy and the offer of alternative employment. So it is a very valid question, because they are two quite distinct stages, and the priority only applies over the second stage. So imagine you've got an employee that she's in a pool of 3. There were 3 employees doing exactly the same job. You only want 2 of them going forward. She's pregnant, or she's on maternity leave, or she's in the 18 months after childbirth phase, so she has priority, but she does not have priority as part of the selection process to identify who is going to be removed from their current job. So the priority does not apply in selection for redundancy in the beginning. It only applies at the next stage, when we say, sorry, your job is no longer there for you, we're going to look for an alternative. So she has the opportunity to have priority, which means she's offered any other jobs, which she can do, even if she's not the best candidate And I think the kind of real nuance about this can be a situation where I've just described is 3 down to 2 in a pool. She is selected for redundancy, no priority. What about if all of those 3 individuals had lost their jobs and then later there are alternative employment opportunities available for her? So thinking about that in 2 separate stages, from an employee's perspective, they may not notice the difference, but from a legal perspective, it is quite different. You can't give priority to her in the schooling process when she's in a pool. You could only give priority to her when she's looking for alternative employment after her existing role is confirmed redundant. So hopefully that answers the question that came through, but it's a good question to ask. And it is going to get clear in your mind when you're looking at somebody who has these protections.
Thanks, Jane. Yeah, that's a really good question, isn't it? We've got quite a few questions, and unfortunately we haven't got the time to be able to answer them all. I'll just answer one further question that's come in, but for those of you who have put a question in the Q&A section, what we'll do is we will look to try to respond to those to you separately when we can. So keep a lookout for a response to those. But the question that's come up, and actually it's come up a couple of times, both now and previously, is in relation to sexual harassment and specifically this obligation to prevent sexual harassment or take reasonable steps to prevent sexual harassment. Is it going to be dependent on sort of the size of your business? So the specific question is, if we've got an organisation that's got less than 50 employees, what's going to be considered to be reasonable? Yeah, I said before that simply doing training alone, it potentially might not be sufficient to tick the box in terms of preventing or to comply with your obligation to take reasonable steps. I think it is true that the smaller the business, the less likely it is you're going to have to do more, if that makes sense. So I think for a business that perhaps has less than 50 employees, as a minimum, you ought to be doing some form of training, I feel. Is that sufficient? Yes, that might be sufficient. A lot of it does depend upon culture, depends upon the type of industry that you're in, the type of business that you have as well. It isn't just going to be about size, in my view. I think it would be about can you demonstrate that you have taken this issue seriously, that you've attempted to do as much as you can within your power to fit within that reasonable box. Employment lawyers love talking about the reasonable band. You'll see my hands. It's from here to here, and that reasonable band. The band of what is reasonable in relation to prevention of sexual harassment has shifted. I think the band has got kind of higher, if you like, if there's more emphasis on it, but it's still within the band. So I think for a smaller business like that, in answer to that specific question, probably training is okay as long as that's done with other elements as well. For a much larger organisation, is training only going to be sufficient? Yeah, it might be. But for me, that's kind of the minimum standard, if you like, that you need to make sure, okay, fine, well, we've got to do that, but then are we doing all the other elements as well? And again, shameless plug, I would say if you get an opportunity, have a look at the DEI training solutions that we've pulled together, because I think we touch on quite a lot of this within that as well. So it's certainly something that's a real live question amount. So we're bang on 2 o'clock. Only remains really for me to thank Jane. Thanks ever so much, Jane. Thanks everybody else for joining us. Like I said, this will be recorded and the slides will be sent out. Have a fantastic rest of International Women's Day, everybody, and I'll see you soon. Thanks so much. Bye-bye.